This courtroom drama is absolutely unbelievable. A self-proclaimed sovereign citizen walks into a foreclosure hearing ready to fight the system, convinced he has cracked the legal code. His home is on the line, the bank is pushing for possession, and instead of hiring a lawyer, he decides to represent himself. What follows is 2 full minutes of pure courtroom chaos. From the very beginning, he challenges the court's authority, interrupts the judge, and repeatedly shouts, "Objection," as if it's some kind of magic word that can instantly shut everything down. But here's the problem, objections only work when they're legally valid. And in this hearing, none of his objections make sense. Not one. Still, he keeps repeating it over and over, clearly believing he's outsmarting the system. Meanwhile, Judge Hillman remains surprisingly calm. Patient. Measured. Giving him more chances than most judges probably would. Even when the interruptions become constant and the arguments start going in circles, the judge sticks to procedure and keeps the hearing moving forward. The turning point comes when the court asks for actual proof, documentation, evidence, something that shows he has legal standing to fight the foreclosure. And that's where everything falls apart. No paperwork. No valid legal argument. Just theories and objections. In the end, the judge rules that he lacks standing and grants the mortgage company possession of the property. Just like that, the house is gone. But even after the ruling, he confidently declares he'll appeal and have the decision overturned, showing he may not fully understand how the appeals process really works. This isn't just a foreclosure hearing. It's a powerful example of what happens when confidence replaces legal knowledge, and the consequences can be life-changing.
You said I'm driving a vehicle. Yeah, you need me to stop? I mean,
I need you to stop, sir. I can't have you driving
give me
while
15 seconds. I can pull it back up to my family house.
No, I can't allow you to proceed while you're driving a vehicle.
No, I'm saying I'm parked. I'm pulling up parking now. I'm parked, right? 5 seconds. Okay, I'm done, Your Honor.
You recall in reviewing your business records if a foreclosure was conducted with regard to this property?
Yes, it was.
Objection, Your Honor, hearsay.
Okay, overruled. You may respond, sir.
On what grounds? So I could maintain the error for the record when I appeal this, if this don't go accordingly?
Okay, it's a business record, sir. That's an exception from
first-hand knowledge. Was he there at the closing table? Like you're practicing law from the bench, I'm gonna respect your courtroom, but I disagree. I disagree. It's tremendous. So, okay. Court reporter, can you please note that the honorable judge, I'm stating he's practicing law from the bench without facts.
But your objection is part of the record, sir. All right. You may continue, Mr. Dooher.
And is this a true, correct, and complete copy of the sheriff's deed of mortgage foreclosure, to the best of your knowledge?
To the best of my knowledge, yes.
And is this sheriff's
objection, Your Honor? Can he vow to that under penalty of perjury? That's the original document.
Your Honor, he stated this to the best of his knowledge.
No, under penalty and perjury, can he contest that that is the original document with the wet blue ink signature? Penalty and perjury.
All right, sir. That's not the question. The question is whether he can identify the document.
Under penalty and perjury, can it be yes?
Sir, you have to stop interrupting.
Penalty and perjury.
You can make an objection, but once you've stated your objection, you have to stop.
Yes, Your Honor.
All right.
And for the record, Your Honor, I do have counsel coming for the next court date. They obtained, as soon as he get back in the country, he will be jumping in to take care of this matter further. So I'll ask if you just give my counsel some time before any permanent decision is made so they can review these books, all interrogatories, so we can make a fair decision. Because I'm not arguing it's a debt, and I've been trying to honor the debt, Your Honor. I'm not arguing that it's a debt. I done did everything possible to honor this debt. They have not been in compliance with it.
And Your Honor, I would object to that, given this would be our third hearing, and he had ample time to get counsel.
Objection again.
All right, let's take one issue at a time, gentlemen. I can't be expected to remember 3 or 4 objections all at the same time. I'm going to overrule the objection on the basis of a business record exception. As to the request to adjourn the matter for Mr. Bay to retain counsel, I'm going to deny that request. Mr. Bay is...
On what grounds, Your Honor? Because I never got served directly.
If you stop speaking when I'm speaking, then I will state my ground. So
I never requested that. You stated that, Your Honor. This is my first time requesting any adjournment to bring in incredible counsel who can handle this matter fairly on my behalf.
At this point, I don't even see that you have standing to participate in this case, although I guess we will get to the truth on that issue. So,
so Your Honor, you don't have my deed of records right there. You don't have me as a deed owner. You don't have me as a certificate owner in the record. I put all that on the record. So for you to say I don't have standing is kind of unfair from my understanding.
And was that redemption date September 27, 2021?
Your Honor, he's coercing. He coercing Mr. Dewhurst.
As a government record and or a document recorded with the applicable recorder of deeds for this this document.
Okay. Any objection to that, Mr. Bay?
Absolutely objection.
Okay. And what's the basis for your objection?
He's a third-party debt collector. He's not a real party in interest, and he has no first-hand knowledge of any of the affairs that took place with this mortgage or at this closing table. And that Mr. Dewhurst he's not eligible to bind a corporation. Do he have the status of a CFO or a CEO in that company? Okay,
so the objection is that this witness doesn't have the
first-hand knowledge to any other matters.
Okay, all right. So the objection is overruled.
And has Carrington ever conveyed any of their ownership?
Objection, Your Honor. Objection.
What basis, sir?
They rightful owner as the title, rightful owner as complete ownership of the property. Can't just take away my interest like that without facts. You guys still have not had no verification of debt. What you have in your hands, Your Honor, we don't reached out. They cannot verify that debt, and they cannot verify that they ever loaned Rachel Brown and Matthew Brown any money for this mortgage. They can't. They can't prove that, and they haven't yet. And I've been waiting. I just want to know if they are real party in interest, are they a real creditor in the amount, so we could handle any financial obligation if owed. They are yet to prove that. Like you said, I got the deed, and it's sealed by the county records. I have the warranty deed as well, and it's sealed by the county records. Objection. Can you prove I didn't redeem and attempt to redeem? Can you prove that it hasn't been corresponding and negligence on you guys' behalf?
Overruled.
The property was foreclosed on and Carrington took control of it.
Okay.
Objection, Your Honor. How can you take control over something that got the taxes in my name? I've been staying there the last year, and I have the deed and the warranty deed again for the record.
May I ask a question that would help?
You may, Mr. Johnson.
Objection, Your Honor. He's about to coerce him again. The question was clear. He could answer that on his own.
Okay.
He said he had 30 plus years of experience. This shouldn't be
made by any party during that time.
No.
And none of your reflections.
Objection.
None of your record.
Objection.
And once again, you have not.
What's your objection?
That's not credible. That's not credible.
Sorry, this is not your time to ask questions, Mr. Bay. Mr.
Okay,
Johnson,
let me know when I'm credible to ask questions.
All right, Mr. Johnson, any other questions?
Has Carrington ever conveyed ownership of the subject property to any party?
No.
Thank you. No further questions, Your Honor.
Objection, Your Honor. Matthew Brown, not the owner at the time that they
Mr. Bay, this is your time to ask questions. So if you want to ask any questions to Mr. Dewhurst, you may ask questions to Mr. Dewhurst.
Okay, Mr. Dewhurst, is it not law that 15 USC 1692G requires verification of any debt?
You want to object as to relevancy?
Okay,
again,
what's the relevancy, Mr. Bay?
I'm establishing bounds for fraud. And since there's no statute of limitation for fraud, I'm going to make sure if they're not their original creditor, that it's fraud.
You didn't respond to the relevancy or how this is relevant.
The relevancy of 15 USC 1692G, it binds any corporation or anybody who's saying there's a debt or a balance to verify it.
Okay, so this is the time to ask questions, not to argue law.
No, I'm
So
not
do
trying
you
to.
have
I'm asking a
do you have
question. That was
do
a
you have a
question.
question regarding the facts from
Yes.
Mr. Dewhurst? Okay, you may proceed.
Yes. So again, Mr. Dewhurst, under 15 USC 1692G, do you have to verify a debt?
I'm going to have to object again regarding relevancy, Your Honor. This is, unfortunately, he does not have standing to bring any claims of verification.
Objection. I'm a real party in interest. Objection, Your Honor. He doesn't have any standing. He hasn't proven he's more than a third-party debt collector yet.
Your Honor, after the foreclosure period ran,
Your Honor, we don't know if this is credible foreclosure. Can I ask my questions, Your Honor?
All right, gentlemen, you cannot speak at the same time.
Next question. So, Mr. Dewhurst, are you conscious of the verification of that letter that been sent to you, to your company twice, that I sent with behalf of Matthew Brown and Rachel Brown, that they're yet to respond from? My notary sent it. The Notary Republic sent it.
Your Honor, I would have to object.
Yes or no?
Sir, you have to let Mr. Johnson state his objection. Mr.
Okay,
Johnson, what's your objection?
Your Honor, he's asking the witness to respond to a vague request if he has any notice, but, you know, I would ask that he would only ask as it relates to the business records, Your Honor.
Objection, Your Honor. I sent that to the Business and Record Department, and I sent it attention to the CFO of the company.
That's an argument. That's not a question. This is a time.
This courtroom hearing turns into one of those moments where you can literally see the gap between confidence and competence unfold in real time. A man walks into court determined to fight a foreclosure on his home. He identifies himself as a sovereign citizen, convinced that the legal system doesn't quite work the way everyone else thinks it does. His house is on the line. The mortgage company is seeking possession. And instead of coming prepared with a structured legal argument or an attorney by his side, he comes in armed with a mindset that he has discovered some kind of hidden legal loophole. From the very beginning, the tension is obvious. The judge attempts to establish order, laying out the purpose of the hearing and clarifying what is at stake. The court is there to determine whether the mortgage company has the legal right to take possession of the property due to non-payment and whether the defendant has any lawful basis to contest that action. It should be straightforward, but it quickly becomes anything but simple. As soon as proceedings begin, interruptions start happening. The defendant repeatedly challenges the authority of the court. He questions jurisdiction. He questions the process. He questions terminology. Instead of addressing the substance of the foreclosure claim, whether payments were made, whether the loan exists, whether default occurred, he shifts the focus to abstract arguments about legal standing, corporate entities, and procedural technicalities that don't actually apply to the situation. The judge remains calm, patient, almost surprisingly patient. Rather than shutting him down immediately, the judge allows him to speak at length. There are multiple moments where the defendant talks himself into circles, repeating the same claims with slightly different wording, clearly believing repetition will somehow strengthen his position. The judge listens, waits for him to finish, and then calmly explains why those arguments are not legally relevant. Then comes the constant stream of objections. Objection. Over and over again. It becomes almost rhythmic. He objects to statements. He objects to questions. He objects to explanations. But objections in court require a specific legal basis: hearsay, relevance, speculation, lack of foundation. Simply saying the word does not invalidate what's being said. And yet, he seems convinced that the more he says it, the more power it carries. The courtroom dynamic becomes increasingly strained. The opposing counsel presents documentation, mortgage agreements, payment history, notices of default. These are tangible pieces of evidence. They represent the backbone of the foreclosure case. In contrast, the defendant offers no documentary proof of ownership interest separate from the mortgage, no evidence of payment, no contractual irregularity supported by law. Instead, he leans heavily into sovereign citizen rhetoric, implying that the financial institution has no real authority over him. The judge attempts to redirect him multiple times. The court explains that if he wishes to challenge the foreclosure, he must present evidence demonstrating either that the mortgage is invalid, the debt was satisfied, or the plaintiff lacks standing to enforce it. But when asked directly for proof of his legal position, the answers become vague. He talks about rights. He talks about constitutional principles. He talks about consent. But he does not present documentation. At one point, he requests additional time, suggesting he may retain counsel. The judge considers it but ultimately denies the request, noting that the matter has already been pending and sufficient opportunity has been given. The court cannot delay indefinitely based on speculative plans to hire an attorney. There has to be procedural fairness for both sides. The mortgage company's position remains consistent throughout the hearing. The loan exists. The borrower defaulted. Proper notice was given. The statutory requirements were followed. From a legal standpoint, their presentation is methodical and structured. It contrasts sharply with the defendant's approach, which relies on disruption rather than structured rebuttal. As the hearing continues, it becomes clear that the central issue is standing. To contest a foreclosure, the defendant must show a legitimate legal interest that allows him to challenge the enforcement action. When pressed on this point, the courtroom grows quieter. The judge directly asks for evidence demonstrating his legal claim to override the mortgage company's right to possession. There is no clear answer. No deed free of lien. No proof of discharge. No substantive legal argument grounded in statute or case law. The judge explains that philosophical disagreement with the legal system does not invalidate contractual obligations. Signing a mortgage creates enforceable rights and responsibilities. Courts operate within established legal frameworks, not alternative interpretations of sovereignty. Despite repeated warnings about courtroom decorum, interruptions continue. The defendant speaks over the judge at times, insisting that he does not consent to the proceedings. But consent is not the determining factor once jurisdiction has been properly established. The court's authority is derived from statutory and constitutional law, not individual agreement. Eventually, the judge reaches a conclusion. After reviewing the record, the evidence, and the arguments presented, the court determines that the defendant has failed to establish standing to contest the foreclosure. Without evidence showing a valid legal defense, the court grants the mortgage company judgment of possession. That decision gives the company the legal right to move forward with eviction of all occupants from the property. The ruling is delivered calmly, clearly, methodically. The judge outlines the reasoning so there is no ambiguity. The decision is based on the absence of legal proof, not on personal disagreement or impatience. The court emphasizes that arguments unsupported by evidence cannot overcome documented contractual obligations. Yet even after the ruling, the defendant remains confident. He announces his intention to appeal, expressing certainty that a higher court will overturn the decision. The judge does not argue. The right to appeal exists. But appeals are not retrials. They focus on legal errors, not dissatisfaction with outcomes. Without a clear procedural or legal mistake in the record, an appeal faces steep odds. What makes this hearing so compelling is not just the legal outcome but the stark contrast between belief and reality. The defendant genuinely appears convinced that he understands the system better than the professionals operating within it. He speaks with confidence. He projects certainty. But the courtroom is governed by rules, rules that require evidence, structure, and legally recognized arguments. The judge's patience stands out throughout the proceeding. Many moments could have escalated into contempt findings or removal from the courtroom. Instead, the judge consistently redirects, clarifies, and provides opportunities for the defendant to present relevant material. The restraint displayed reinforces the principle that courts strive to provide fair process, even when one party refuses to engage productively. By the end of the hearing, the contrast is undeniable. On one side, documented evidence and procedural compliance. On the other, repeated objections and ideological assertions. The legal system does not operate on volume or persistence alone. It operates on substantiated claims. This case becomes a powerful illustration of the risks involved in self-representation, especially in complex matters like foreclosure law. Legal procedures are technical. Deadlines matter. Evidence rules matter. Standing matters. And when someone chooses to navigate the terrain without understanding its structure, the consequences can be severe. The final image of the hearing is not explosive. It is not chaotic. It is procedural. A judgment entered into the record. A property legally transferred into the possession of the mortgage holder. A homeowner facing eviction. And a lingering sense that the outcome might have been different had the defense been grounded in recognized legal strategy rather than defiance. In the end, the courtroom does not respond to slogans or repeated objections. It responds to evidence, law, and procedure. And in this hearing, those elements ultimately determined everything.
No, that was in the form of a question. You didn't let me finish, Your Honor.
Okay, well, you can't ask multiple questions within the same question.
Okay. Well, Mr. Dewhurst, what was the problem answering the verification of that letter? If you have that in the record. So we've been asking for the original.
Objection, Your Honor. He stated that he was not aware of a letter.
Right, correct. So I should say then, moving forward, is there a problem producing the original contract with the wet bluing signature from Rachel Brown and Matthew Brown? If you have that in the records.
Okay, so you have a question for Mr. Dewhurst?
Yes, Mr. Dewhurst. Is it fair to say you cannot prove that the original, you don't have access to the original copy of the note of the mortgage?
Yes, I'm
under
sure.
penalty and perjury, do the company have it, Mr. Dewhurst?
So you may ask another question.
And okay, also, Mr. For you, Your Honor. So it's also credible and fair to say he has no firsthand knowledge of anything as well.
Okay, so that's an argument. That's not a question. Okay. So yeah.
All right, I'm learning. I'm sorry, Your Honor. Thank you for your patience. So Mr. Dewhurst, under penalty and perjury, can you confirm that your company followed all GAP procedures with this process?
Objection, Your Honor. So
I guess the last question, again, I just want to confirm that Mr. Dewhurst, you have no firsthand knowledge of the of Carrington Mortgage being the creditor in this loan for this mortgage. So that's still kind of broad, Your Honor. I want for the record for him to say, are you guys the creditor, or you don't know?
Asked and answered.
No, that's not asking and answer. I'm asking directly, Mr. Dewhurst. Is Carrington Mortgage? Can you confirm they're the creditor of this loan or this note, or you don't know? And I'm asking that for lawful reasons.
And so, by bidding the highest in the sheriff's sale, what interest does that give Carrington then in this proceeding?
Within the creditor.
Okay. All right.
Allegedly. So that is true if that's the case. But if, Your Honor, or court, if Carrington can never prove they ever issued anything, is it fair or is it lawful to state that they never have the right to say they hit with the highest bidder with anything.
Any more questions for Mr. Dewhurst, Mr. Bay?
Not at this moment, Your Honor.
Okay.
Not at this moment. I'll let my counsel deal with that.
Okay. Does the plaintiff rest?
Yes, Your Honor, but if I may just conclude with a couple things, if that's okay?
Well,
Objection, Your Honor.
if you have
Statement and brief from counsel is sufficient for summary judgment.
And to show that there was indeed a foreclosure sale conducted on March 25th, 2021.
Objection, Your Honor.
And this is final argument, so that you can't object to that.
Okay, I'm sorry, Your Honor.
All right. Additional final state arguments, Mr. Bay?
Yeah, again, Your Honor, you know, he's wasting judicial resources because, again, I have proof on file and on record, correspondence. We try to resolve this matter. At this time, I would like to bring my counsel in. They'll be back in the States in a couple of weeks. And also, Your Honor, can I request that Mr. Johnson put his bond on file? Can I get his bond information, his liability bond for this matter as well?
Okay, no, that's not an issue in this case.
I ask for you to just honor my motion, honor my counterclaim to dismiss this matter, because they don't have, it's not a, nobody with real party and interest on this line right now. Nobody with firsthand knowledge is on this court case right now that can speak and contest to what's going on. So with that being said, I ask to adjourn this matter or dismiss this matter because for failure to state a claim upon which relief can be granted.
An individual who's identified himself by the name of Amate Bay claims to have a possessory interest in the property, though he did not present any proof on the record today of any interest that would make him have standing to contest this mortgage foreclosure and this suit for possession. So based on the proofs on the record, the court does find that Carrington Mortgage Service LLC does have the right to possession, and therefore a judgment of possession against Amate Bay and all occupants of the premises is granted.
What is my time frame to no, can you just for the record, so there's no contract with Amate Bay and Carrington Mortgage in this matter, right?
Sir, I'm not going to explain my ruling to you. I just ordered that the Carrington Mortgage would have the right to get an order of eviction, removing all occupants from the premises.
That's fine, Your Honor. I'll make sure it get overruled in a higher court. Thank you.
Okay, all right. That's all for the record. Thank you, gentlemen.
Thank you.
Your Honor.